third piece of legislation, now this hasn't got quite as far as these other two pieces of legislation. So the Neonatal Care Leave and Pay Act has received royal assent, which means that it is now firmly established as a piece of legislation, and regulations now must follow to implement it. Now, this next piece of legislation, as you will see, is still referred to as a bill, the Worker Protection Amendment of Equality Act 2010, Bill of 2022 to 2023. This piece of legislation has seen a bit of an up and down route through the House of Commons and the House of Lords, because it has to go through various readings before it gets approval. This piece of legislation has now had, just last week, on Friday of last week, it's had its final reading in the House of Commons, and has now been approved. It hasn't received royal assent yet, but that should be a formality. So, cut to the chase, Matthew. What on earth is this legislation doing? Well, it's going to introduce a proactive duty on employers to take reasonable steps to eliminate sexual harassment from their businesses. So, you might say, well, surely we do that anyway already, don't we? Well, as far as the law is concerned, do employers actually have to do anything to stop harassment in the workplace? And quite frankly, although this seems like a stupid question, there's nothing at all that employers are required to do in law. Nothing. That's not to say that there aren't consequences for employers if they don't try to stop harassment. Workers and employees can, of course, bring claims of harassment under Section 26 of the Equality Act. But the bringing of the claim in itself doesn't necessarily mean that an employer has to do anything to stop harassment. After all, they can settle claims and just carry on as before, as perhaps is evidenced by a number of the high-profile cases that came out of the Me Too movement. So this called into question whether the current legislation actually works. Well, so what progress have we made since the Me Too movement? Well, arguably, it's very limited. We've seen a report, and I'm sure you probably read about it in the press. We saw a report recently that nearly 2/3 of female surgeons said that they'd been the target of sexual harassment. And a third had reported that they had actually been sexually assaulted by colleagues in the past 5 years. And these are truly horrendous statistics. And so it now appears that we're going to have legislative change in order to require employers to take preventative action. And that's what this bill does. As I said, it appeared to have stalled in the legislative process, but that's because the House of Lords in particular were objecting to a significant part of the legislation, which set out a reintroduction of third-party harassment. Now, I'm not intending to get into third-party harassment now. Essentially, the House of Lords objected to that, so that's been removed from this legislation. But however, as I said, the legislation has now passed its final reading. So what does the legislation say? So let's have a look at what it says. So it's going to introduce a legal duty on employers to take all reasonable steps to prevent sexual harassment. And sorry, I'm just going to correct myself there, because I've just said all reasonable steps, and that's incorrect. It will introduce a legal duty on employers to take reasonable steps to prevent sexual harassment. The reason I just said all reasonable steps is because the House of Lords did water down what employers need to do. The legislation originally required employers to take all reasonable steps to prevent sexual harassment, and that's been watered down slightly to requiring employers to take reasonable steps. So not all reasonable steps, just reasonable steps. So what do we mean by reasonable steps? That is a bit of a question which I'm going to turn to on the next slide. But before I do so, one of the interesting things of this, of course, one of the additional interesting things of that is that this legal duty will not apply to the other forms of protected characteristics in the Equality Act. This is focusing solely on sexual harassment. Although, of course, I would have thought that many employers, under their obligation to address sexual harassment, take a proactive step to eliminate sexual harassment from the workforce, will also take similar action in relation to the other protected characteristics, but there isn't actually a legal requirement to do so. So what are these reasonable steps? What do we have to do? Well, it's always interesting for us as advisors and also employers to get some guidance from the tribunal about the use of reasonable steps. So essentially what we've got at the moment, so reasonable steps already exists. So currently under section 109 of the Quality Act, essentially it states as follows, that in proceedings against an employer in respect of anything that's alleged to have been done by the employer in the course of that person's employment, it is a defence for the employer to show that it took all reasonable steps to prevent the harasser from doing the thing that they did. What this means is that as an employer, if an employee of yours acts in a discriminatory way towards another employee, then you can avoid liability for that if you've taken all reasonable steps to prevent them from acting in that discriminatory way. So in order to be able to run this reasonable steps defence, all reasonable steps defence, it is commonly regarded that the minimum that an employer must do as an absolute minimum is have an equal opportunities policy or an anti-harassment policy, that the policy has been clearly and effectively communicated to everyone, that training has been undertaken in relation to dignity at work, equal opportunities, harassment, and that action is taken when complaints are raised within the business. So I'm sure an awful lot of that is rather familiar to you. Many of you will have these policies in place. Many of you will be ensuring that those policies are communicated. Many of you will have undertaken training in relation to dignity at work or harassment or equal opportunities, albeit that I must admit that I do find that the consistency of that training, the quality of that training, the regularity of that training can be problematic in some employers. And so what do we mean as reasonable steps? So what do the tribunals think of reasonable steps? So what I thought it would be quite helpful to do is just to highlight some recent cases that have set out what they think about whether an employer has taken reasonable steps. Because of course, this is going to form the basis of this proactive duty that employers are going to have. So in this case, the Leader and Hossack case, which actually, as you can see, involves Leeds City Council, but because Leeds City Council successfully ran the all reasonable steps defence, they were therefore removed from the proceedings, the later proceedings that continue, which is why they're not named in the case. But Leeds City Council was successful in demonstrating that they had taken all reasonable steps in showing that they had a clear dignity at work policy, they trained all staff, and they had a culture of allowing employees to raise concerns. So that all seems quite straightforward, doesn't it? So in many instances, an employer is then going to feel, or you might read that and feel quite confident in where you are as a business. But then we've got this quite recent case of Fisher and London United Busways Limited. Quite an interesting case. I'd encourage you to go and have a read of it because it's one of those cases where the tribunal clearly identified quite early on that harassment had not taken place. But notwithstanding that, they took the opportunity to really delve into a couple of issues and give their views about things. And one of them that they took a view on was the reasonable steps defence that was run by London United Busways. Now, London United Busways is quite a large employer. It provides bus transport services in London. And they ran the reasonable steps defence in this case. And in this case, they had all of the following. So they had an equal opportunities and harassment policy from 2007. The policy emphasised that it had a zero tolerance approach to the enforcement of the policies. The policies were not only given to all employees, but it was also provided to all the agencies that provided workers to the business. The policies were part of the employer's induction process. Everyone was encouraged to report concerns, and there was evidence that complaints were investigated and addressed. So again, you might have a look at this and think, well, how's that different to the leader case that we just looked at? Surely that is going to be sufficient for a reasonable steps defence. Well, you can clearly see where I'm going with this, because it wasn't. So what the tribunal said was that they should have more up-to-date policies. So their policies hadn't been updated since 2007, and they said that that wasn't sufficient. The policies had to be clearer. They had to be clearer about what sort of behaviours were unacceptable. They had to be clearer about who they apply to. They had to ensure that the approach of the business isn't just about equality, but it's also about inclusion. So this is where the fact that the policy dated back to 2007, this is where the tribunal was saying you haven't kept up to date. It's not just about equality anymore. It's about diversity. It's about inclusion. It's about the inclusion of minority groups at work. But although the policies had been sent to all agencies, and that they were part of the induction process, that the communication of the policies should have been improved. Notice boards weren't sufficient. That the training that they had should be regularly refreshed and more detailed, that also address the meaning of terms, for example. So the use of language, what sort of language should we be using, and what sort of language should we not be using? That an organisation of the size of this employer should also have had employee representative groups. So, for example, the minority group, so the LGBTQ plus representative group, or a minority ethnic representative group, and that support from an employer in the formation and operation of such groups can allow ideas for improvement to come from diverse groups and enrich and improve the business's approach to issues affecting those groups. Effectively finding a way to communicate directly with all of the different groups within your business, so that you know how to properly include those minority groups within your business. And so that's what the tribunal said should have happened. And so, as you can see, that really is quite a comprehensive list of things that an employer should be doing. And it really does set the bar quite high. Now, as I've already said at the beginning of this, is that what the legislation is doing, though, is it's not necessarily setting the bar as high as this, because the legislation that is going to require employers to take proactive steps to eliminate harassment, sexual harassment in the workplace, is reasonable steps and not all reasonable steps. So we are going to need to have some guidance on what this actually means. And we've been promised that the Equality and Human Rights Commission is going to publish some guidance around this. And also to let you know about where we are in terms of the enforcement of this, is that the enforcement of this is going to be done by the Equality and Human Rights Commission. So what this effectively means is that there's the possibility of, in a case where, say, for example, you haven't taken these proactive steps, or arguably you haven't taken these proactive steps to eliminate sexual harassment from your workforce, then when you receive a complaint of sexual harassment, then that individual may threaten or actually do so in making a complaint to the Equality and Human Rights Commission. So effectively reporting the business to the Equality and Human Rights Commission and asking them to investigate. Perhaps in the same way that where an individual alleges that we breached data protection, that they will do so, make those complaints to the Information Commissioner. The Equality and Human Rights Commission can then investigate, and they will have the power to intervene and to fine businesses. Although it's not quite clear at this point in time what we are looking at in terms of levels of fines. More practically, what can also happen is that there is likely to be a a provision within the legislation that is then going to allow the increase in compensation at tribunal. So in the same way at the moment that if you don't follow the code of practice for disciplinary and grievance processes, you then lose a case in tribunal in relation to, say an unfair dismissal claim, then the tribunal can uplift the compensation as a penalty by up to 25% for your failure to follow that code of practice. And this will happen with sexual harassment cases as well, where the compensation can then be increased. So there is obviously there is, of course, employers should be taking steps to eliminate sexual harassment from their workplace in any event. I think we would all agree on that, and that's a given. But the bottom line of this is that if you don't, it's going to cost you money. So we can provide you with a template sexual harassment policy. Now, I'm sure you all have anti-harassment policies, but those anti-harassment policies tend to be quite broad and generic, certainly from my experience of the ones that I have seen. And in order to ensure that you are actually taking proactive steps to eliminate sexual harassment specifically, then I would strongly encourage you to get a sexual harassment policy in place. One of the other things that tends to come out of all of these cases is in relation to training. And as I said, that's probably the one area where employers are most inconsistent. So you need to have a look at your training. Now, of course, we can help you with that training. I say we can help you with that training. We can help you with that training. We can deliver that training for you, whether that be diversity and inclusion awareness training more broadly, either for all employees or more specifically for team leaders, supervisors, managers, about how to address complaints, how to be on the lookout for complaints. Because obviously the responsibilities for team leaders and supervisors and managers is different to employees. So you need a different training session for those individuals. And then more specifically, obviously, in relation to sexual harassment, so sexual harassment awareness training for all employees, and also then specific training in relation to managers regarding what they should be looking out for and how they should be dealing with and addressing complaints. We've got e-learning packages which you can use. We can also come into your business directly and conduct investigations into sexual harassment. We can conduct grievance and disciplinary hearings into sexual harassment as well. Or, of course, we can provide some training in relation to your own employees in order to enable them to feel comfortable and secure about what they should be doing and how to approach complaints about sexual harassment. Because complaints of harassment, and I'm hesitant to say particularly complaints of sexual harassment, but I've got to say that certainly the complaints where I have got really very close and first-hand experience of, from an advisor's point of view, and from conducting meetings, is that sexual harassment is probably one of the most upsetting areas. That's not to say that the other areas of protected characteristics, whether it be racial harassment or the other areas, are not upsetting. I'm not saying that whatsoever. But often sexual harassment can be a very difficult one for employers to deal with, and for managers to question employees about, and therefore investigate these issues. So if you want some help with that, then obviously please do get in touch with us.